live, but you're still technically on this probation here in Texas, so it's not like the whole. Well, no, there's one fee, but you will have to report either by mail or online here as well each month. So you're going to go in person there, and you also have to report here. So you can't forget to do that mail-in or the online reporting here, because that would be a violation. It's just a lot of people they think they're doing everything right because they're reporting in person over there, but you have to stay in touch with us as well. All right.
Judge, real quick, I apologize. There is one thing I spoke to Mr. Megan about this previously. It seems to be maybe a new charge in Georgia. I don't know I don't know the circumstances of this, nor do I recognize the charge.
Yeah.
And it's equivalent with us.
Hang on, ma'am.
So that's the only thing that's new that I wasn't aware of, and I spoke to Mr. Megan about before, and he was going to find out.
Okay, so whatever you have to take care of, obviously in Georgia with regard to.
I don't have anything to take care of. That was what they were reporting in Georgia.
That's the case, Judge, but
I got the car accident. They arrested me because they had a warrant.
I got you. Okay. All right.
But I believe they dealt with that. Well,
Okay.
there's nothing to deal with. I just had to find out.
That's where you got arrested, and then they transferred you here.
I didn't get transferred. I was on sick jail for 44 days.
Okay.
To find out.
Okay. Got it.
that's
Okay.
sufficient for the state.
All right.
I just didn't know.
Okay, Ms. Cassidy, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient
I have a question. This packet, it sounds like I had to do like 300 hours of community service.
So explain all that to probation.
Yeah, that's what happens when you're on felony probation. It's required. If you talk to your probation officer, if you're doing everything right, sometimes they waive part of those, sometimes they don't. It depends on how you're doing. Do you understand? This could be a lot worse, so you probably need to fix your attitude real quick. Because having a bad attitude with me does nothing good for you. Okay. So I'm going to find sufficient evidence to find you guilty, and at this time, I'm going to follow your agreement and defer all proceedings and place you on probation for 4 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, at the end, the case is actually dismissed. You will never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty and sent to prison for anywhere between 2 and 10 years. Do you understand? Okay. One thing is, on these types of probation, if you do everything you're supposed to, I sign early terminations from probation all the time. But it means you have to get it all taken care of early and up front. So take care of everything, and then there's the possibility of getting off early. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, ma'am. Thomas Fisher, Mr. Macon? Good, thank you. How are you?
This is his father, Judge. We're bringing him up. I don't know if you want to put this on the record or not, but since this case has been initiated, his father has been essentially acting as a guardian for Chad's whole life. We've gotten that formally done. So I want him to at least be available to participate if Chad has any questions or anything like that.
Okay, and so
he is technically legally under guardianship at this time, and so
okay.
That's why there's 2 signatures on the plea rejection
Okay.
form, and Mr. Hoffpower, I think, is aware of all of this.
Okay, all right, you're Chad Cracknell?
Yes, ma'am.
And Mr. Cracknell, in cause number 22, hold on, let me get. Cause number 22-39948, you're charged with the second-degree felony offense of solicitation of prostitution from February 26th of 2021, and that's for under 18. And what that means is that if you go to trial and you're found guilty by a jury, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And I have here on the computer a plea bargain rejection that you've signed, and it looks like your dad and your attorneys, that shows that the district attorney's office has made an offer if you wanted to plead guilty for a 10-year term in prison, but you would serve that on probation instead of in prison. Do you understand what they have offered you? And you have every right to reject that and have a jury determine if you're guilty, and that jury can decide what your punishment is. And if you go forward, I just want to make sure you understand what your options are if you wanted to enter a plea of guilty today, what the consequences could be if you go to trial. And do you understand all of that?
Yes.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Okay? Then we'll get it set on the trial docket, and your lawyers will begin preparation for trial, okay? Y'all are free to go. Thank you.
Thank you, Judge.
Thank you.
All right, ma'am. Again, you're Carolyn Whitaker. And is the offer in each case, or is it in one
First degree felony.
with a dismissal of the other, or what?
Would be, if the agreement is cap, it's a cap offer with the dismissal.
With the dismissal, I'm gonna,
If we need to do another one,
no, I just want to fill in the dismiss cause number with everyone's permission.
that's good.
That's part of the plea bargain. No, that's okay, reject.
Much more high-tech down here.
I know. When it works, we are.
I had to get some help.
It is nice once you kind of get used to
It is.
it, but, okay. So, Ms. Whitaker, in cause number 24, DCCR 2182, you're charged with the first-degree felony offense of aggravated sexual assault from September 17th of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishment is between 5 years and up to 99 years or life in prison. Do you understand? And I have here on the computer a plea bargain rejection that has your signature with Mr. Morian's that shows that the state has offered, if you wanted to enter a plea of guilty, for a cap of 40 years in prison, which means you would be leaving your punishment up to me, but if I followed that agreement, I couldn't give you more than 40. I can give you 40, I can give you less, I can consider whatever. That would all take place later at a sentencing hearing. You have every right to reject that and have your case set for trial. I just want to make sure you understand all the consequences and possible options. And do you understand that? And do you want to reject that offer and have your case, both cases set for trial? And I don't think I said it, I talked about it, but that part of that plea offer would be for a dismissal in the injury to a disabled individual. Do you understand that as well? Okay, and so I want to make sure that after today, you understand as well that I will not accept, once cases are on my trial docket, I don't accept plea agreements like the same one unless there is new information that either your attorney or the state's attorney did not know today. So once it gets on the trial docket, it's expected to go to trial. If you wanted to change your mind and enter a plea, it would be to something different than this. Do you understand? Okay, we'll get it set on the trial docket. Mr. Morian will begin preparation. Good morning, ma'am. Are you Michelle LaChasse? And this is cause number 2239304. Ms. LaChasse is on probation for abandoning or endangering a child. It's a state jail felony. And that probation was for a 3-year deferred probation, October 17th of 2022. Has that been extended? Okay. So obviously, we'll see what we do today, but if there's going to be safety, I think that would be a requirement for me to do that. So I received an administrative hearing on April 30th from Mr. Ruiz with some issues that have been going on with regard to Ms. LaChasse allegedly going to the Sky Bar Lounge, failing to adhere to the curfew, failing to adhere to mental health services and treatment plans, remaining compliant with medication, admitting to drinking, and also admitting to trying to locate drugs as well. That hearing recommendation was to continue supervision and request SafeP, which was agreed at the time by Ms. LaChasse. I signed off on that and ordered it. Mr. Nix has filed a motion asking that I reconsider that. I have asked probation for kind of an update in their response to that, as well as the state, who said pretty much it's up to me and probation and everything else. So it's my understanding, Mr. Nix, that Ms. LaChasse is wanting to do some kind of local inpatient treatment.
So Your Honor, if I could briefly just kind of give a little bit of a recap. She had her medication switched on March 11th, and March the 20th. And shortly after that, if I can present this, I've shown a copy to the district attorney's office this morning. It showed that they made a major medication change, took her off Seroquel, put her on Prozac. She immediately started having issues with the Prozac. She's still having issues with the Prozac. She's taking the Prozac at the jail. They're giving it to her. She's having issues. What we've done is we've spoke to Baptist hospitals. I have her mother and I have her fiance here. We have documentation that she would be accepted into inpatient at Baptist Hospital. Also have a letter from her doctor.
But that's just a 5 to 7 days.
No, they can actually keep her inpatient for up to 30 days, Judge, and then they have an outpatient program that could continue after that. If I could present this is a letter from her doctor that kind of underlines her very exacerbated issues. What I'm asking the court to do is not to exactly undo the SafeP. What I'm asking the court to do is hold the SafeP in abeyance, give her a chance to do the inpatient Baptist, make sure that she's on the right medication. I presume that a major medication change is about to take place due to the fact that she's having such issues with the Prozac, and we reconvene after she's completed an inpatient stay. Whether it be 14 days, whether it be 30 days, I'm assuming it'll be 30 days based on what the fiance's talked to with Baptist. It would come at no cost to the taxpayer or to probation. We've already cleared it with her insurance. She's stayed there before, and insurance covered almost 100%. I'm asking the court to just hold the SafeP in abeyance until she can do the inpatient treatment. We reconvene in 30 days and see how she did in the inpatient treatment. And then depending on how the reports go, how everything that I turn over from her inpatient stay to both probation, the state, and the court, you decide if SafeP is still in her actual best interest at this point. We understand that SafeP is also a blessing. She could have been sentenced to state jail time. We're not underscoring the issues. We're explaining to the court that this is a mental health issue caused by a major medication change that's documented. Her issues follow immediately after this, and she's still on the Prozac, and she's still having lots of problems in the jail on the Prozac. We're asking that we just hold this in abeyance. I'm not asking the court to undo it, take it away, put her back on regular probation. I'm not asking for that. I'm asking to hold it in abeyance, place her, allow her to be placed in the inpatient.
Do we know, is it up to the hospital how long she stays?
I believe so, Your
I can't
Honor.
order some
Correct.
certain amount of time.
Correct. And however long that is, if it feels that it's not long enough, we can reconvene and I can show you the records at that point and we can make a decision from there. But Baptist has told the family that it would be up to 30 days and then they have an outpatient treatment that can continue after that. Now, of course, we won't know if that's appropriate until we see how she does in there, but it's pretty clear that this is a medication change that caused this behavior.
Mr. Nichols?
Judge, the main hesitation on our part is that she agreed to SafeP and now wants to do things on her terms. I think SafeP is where she needs to be based on the relapse and violations she had. And I want to bring the court's attention, when she was first put on probation in 2022, she was ordered ISF. Didn't want to go to a private inpatient program in Harris County, which she was discharged unsuccessfully from. So it's almost like we're rewinding the same script as before, and it obviously didn't work then.
I didn't see that.
I don't think it's contained in the admin. I think Mr. Rudes can testify to that, though, Your Honor, if you want more detail. He informed me about that this morning.
Okay. Do you have any disagreement with regard to what happened at the beginning of probation that they're talking about, Mr. Nix?
I'm not sure that I was a part of that, so I don't know that I can speak to that. What I can speak to is that they made a major medication change that immediately caused these issues. SafeP is a wonderful program that's helped a lot of people. I don't know that it's fine-tuned for her mental health issues that are causing the issues right now. I think it's a fantastic program, and I still think she might end up there, but I think if we get her the right mental health treatment and get her on the right medication, she's much more likely to be successful in SafeP if she has the right medication and she is of the right frame of mind.
The special needs SafeP facility, do they adjust medications and things like that?
Yes, ma'am.
Yeah. I think based on what I know now from the beginning, that we ordered or agreed or whatever happened with ISF, and then agreed to allow her not to do what everybody else thought was appropriate, go to her own choice. unsuccessfully discharged from that, and here we are having the same problem. So I'm not going to adjust that order.
Yes, ma'am.
I am going to order the special needs. It's special needs safety. It's not the regular one. It is, the whole purpose of it is to treat both things. And so that can all take place there, and I think that would be better for her and for our community. In addition, I am going to, because of the issues in the administrative hearing, the fact that a motion hasn't been filed, the length of time, I think, obviously is an issue, and so I am going to also at this time order that Ms. LaChasse's probation be extended by 2 years. That should give plenty of time to get through the program, get through aftercare, make sure everything is going like it should be, and then hopefully get off this probation without a conviction or going to state jail. All right, I know it's not what you want. I hope you take advantage of it, however. It's a good program. You can talk to them about medications and get stabilized before you get out and get on aftercare. Okay, thank you, Mr.
Thank you,
Nix.
Judge.
Thank you, Mr. Ruiz, for being here as well.
And there it is, a courtroom that looked routine, but carried consequences that could change lives forever. In just a few minutes, we saw how thin the line really is between freedom and years behind bars. One missed report, one bad decision, one moment of attitude, and everything can collapse. The judge didn't raise their voice, didn't need to, because in this system, the rules speak louder than emotion. Some were given chances, others walked closer to risk, but all of them now stand on a path where every step matters. This wasn't just about law, it was about responsibility, choices, and the weight they carry long after the courtroom empties. So the real question is, when pressure hits, and no one is watching, would you make the right call, or become the next case standing in that same spot?